Let's dive right into this. If you are studying business and industrial laws, the Factories Act of 1948 is absolutely crucial. It's one of those heavily tested areas you're guaranteed to see on your professional written exams. So we are going to break this entire roadmap down, piece by piece, so you can walk into that exam room feeling totally confident and ready to crush it. Grab your notepads. We'll be tackling the Act's main purpose, nailing down those tricky legal definitions, figuring out what legally makes a factory, looking at who the occupier is, and finally diving into health, safety, and working hour limits.
So, starting us off with Section 1, the actual purpose of the Act.
Now, examiners love to test if you actually understand the why behind a law before they test you on the technical stuff. You need to highlight the Ravi Shankar Sharma versus State of Rajasthan case in your notes. It's a perfect illustration. The court essentially said, look, the Factories Act is fundamentally a piece of social legislation. Its entire goal is to promote health, safety, and welfare, and literally protect workers from being exploited by greedy business establishments. If you get an essay question about the Act's intent, dropping this exact case name and the phrase social legislation is going to make your answer instantly stand out. Okay, moving right along to Section 2, key legal definitions. In industrial law, specific words carry a lot of weight. Let's look at Section 2K, manufacturing process. You might instantly picture an assembly line building something from scratch, right? Well, actually, the legal scope here is massive. A manufacturing process includes making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, or demolishing. Basically, it's treating or adapting any article for its use, sale, transport, delivery, or disposal. It even covers things you wouldn't expect, like pumping oil, water, or sewage, generating and transmitting power, printing, repairing ships, and even just keeping articles in cold storage. And to really cement this for your exam, let's look at a fantastic case study, Qazi Nurul Hassan versus the Deputy Director of ESIC. This case is absolute gold because it proves that even a petrol pump doing basic repairs legally qualifies as a manufacturing process. The court ruled that the definition absolutely does not depend on an end product being created. You cannot interpret this in a narrow sense because remember, this is a social welfare act designed to protect people. Keep this case in your back pocket for any scenario questions about repair shops. Next up is Section 2L, the definition of a worker. Make sure to specifically note that this explicitly includes people hired through third-party agencies or contractors. A worker isn't just someone the company hires directly. Even if they are working without actual wages, remuneration or not, if they are involved in that manufacturing process or cleaning the machinery, the law says they are a worker. Period. So, what happens if an exam question asks you about construction workers? You immediately cite the Lal Mohammed case. The Supreme Court made it crystal clear. Employees of a construction company are indeed workmen under Section 2L because their project work counts as a manufacturing process. Having these specific case illustrations ready to go is exactly how you turn a B-grade answer into an A+. Let's jump into Section 3, interpreting what a factory actually is. Under Section 2M, if a premises doesn't legally qualify as a factory, the rest of this act doesn't even apply. You have got to anchor these exact numerical thresholds in your memory. It's 10 workers if the work is done with the aid of power, like electricity or machinery that speeds things up. If you have that power aid, it only takes 10 workers working on any single day in the preceding 12 months to legally become a factory. But if everything is done manually without power, that threshold doubles to 20 workers. Now, let's test your legal intuition with a classic trick question examiners love to use. Imagine an employer installs 20 computers in a regular office and has 30 people working on them. Does that office suddenly become a factory? The answer is a hard no, and you can prove it using the Seal and Raj case. The court confirmed that just installing an electronic data processing unit, or computers, does not turn an office into a factory, provided that no actual physical manufacturing process is happening there. Moving to Section 4, the role of the occupier. When the factory inspector comes knocking, or heaven forbid, an accident happens, the occupier is the person who has to answer for it. Under Section 2N, this title goes to whoever has ultimate control over the factory's affairs. In a partnership, any partner can be the occupier. In a government facility, it's whoever the government appoints. But things get a bit tricky when we talk about massive corporate companies. And that's where the Container Corporation case comes in as a major exam differentiator. A corporate entity literally cannot pass the buck to a lower-level middle manager. The law says a director of the company must be the one notified as the occupier. The legal burden rests right at the top, on the board of directors. Section 5 brings us to health, safety, and welfare. The occupier has massive responsibilities here, and it's easiest to memorize them in 3 buckets. First, health. Keeping things clean, managing dust and fumes, and providing proper ventilation and separate latrines. Then, safety. This is huge. They have to fence off dangerous machinery. Plus, you need to know about Section 2CA and CB. For carrying out tests and inspections, you need a competent person, someone officially recognized by the chief inspector based on their specific qualifications and facilities. And for a hazardous process under Section 2CB, which is any process that could cause material impairment to health or pollute the environment, there are super strict rules like needing a site appraisal committee. Finally, the welfare bucket, providing basics like washing facilities, sitting areas, and first aid. Let me give you another magic number to memorize: 250. This is the exact threshold of workers required before a factory is legally mandated by Section 46 to provide a canteen. If a factory has 249 workers, a canteen is completely optional. But the very day they hit 250 workers, it becomes a strict legal requirement. Section 6. Rules on working hours. The Act places very strict limits on how long people can work. Under Section 54, 9 hours is the absolute maximum an adult worker can be required to work in a single day. And when you zoom out to the whole week, Section 51 caps that at 48 hours strictly. So, 9 hours a day, 48 hours a week maximum. Oh, and workers are legally required to get a half-hour rest interval after 5 continuous hours of work. But what happens if they go over? Enter Section 59. Highlight this. Anytime a worker crosses that 9-hour daily threshold or that 48-hour weekly threshold, the law mandates they get paid double their ordinary wage rate for the overtime. That is a massive worker protection, creating a strict legal obligation for the employer to pay up. And if employees decide to ignore any of these rules, the penalties under Section 92 are severe. Memorizing these exact figures makes for a brilliant conclusion to any exam essay. The occupier or manager could face up to 2 years in prison, a fine up to 1 lakh rupees, or both. And if they get convicted but keep breaking the rule anyway, that's an additional fine of 1,000 rupees for every single day the contravention continues. The law definitely has teeth.
We are specifically mastering 2 very crucial, highly tested sections of the Factories Act of 1948, Section 2L, which defines a worker, and Section 2M, which defines a factory. We're going to strip away all that complex legal jargon and use some clear, structured takeaways to make these rules actually stick in your memory.
But before we completely lose ourselves in the heavy legal text, let's test your intuition with a really relatable legal ambiguity, one that honestly trips up students all the time. Imagine a standard, everyday office room. Got it? Now imagine the company suddenly installs this massive electronic data processing unit, or a huge network of advanced computers right in that room. Suddenly, you've got machinery, you've got heavy power running, and you have people operating it. So does installing those computers magically transform that office into a factory under the eyes of the law? Keep your answer in the back of your mind, because as we dissect the statutory text today, we're going to find out exactly how the courts view this modern workplace scenario.
All right, here's our roadmap for today. We'll start by defining a legal worker, then look at the Lal Mohammed case study. After that, the definition of a factory, followed by the Seelan Raj case study, and we'll wrap up with your final exam takeaways.
Okay, let's dive right into Section 1, defining a legal worker. Now, law exams require absolutely precise terminology, so here is the exact legal definition of a worker under Section 2L of the Act. Deep breath. Here we go. The statute states that a worker is a person employed directly or by or through any agency, including a contractor, with or without the knowledge of the principal employer, whether or not for remuneration in any manufacturing process, or in cleaning any part of the machinery or premises used for a manufacturing process, or in any other kind of work incidental to or connected with the manufacturing process, and it explicitly states it does not include any member of the armed forces of the Union. Wow. Okay, reading that as one massive sentence is just exhausting, right? Let's fix that.
We can easily memorize this whole thing by breaking that rigid legal paragraph into a really simple 5-point checklist. First off, it doesn't matter if the person is a direct hire or brought in through a third-party contractor. Second, the principal employer doesn't even need to know they are there. If they're working through an agency, they are covered. Third, And pay attention, because this is a massive trap in multiple choice questions, whether for remuneration or not. Yes, an unpaid person can absolutely be a legal worker under this act. Fourth, look at the actual nature of the work. It has to be tied to a manufacturing process, or cleaning the machinery for that process, or doing incidental work connected to it. And finally, memorize this strict exception. Members of the armed forces are never, ever classified as workers under this specific section. Moving right along to Section 2, Case Study, Lal Mohammed.
Picture this exact scenario popping up on your exam. How would you apply the checklist we just learned to answer it? The case here is Lal Mohammed v. Indian Railway Construction Co. Limited. You have a construction company building a project, and they employ a whole team of construction workers. The big legal question that actually made it all the way to the Supreme Court was this: do these construction workers squarely attract the definition of the term workman or worker under the Factories Act? Think back to our checklist. Well, they are employed, but are they actually involved in a manufacturing process?
Well, here is what the court decided. The crucial point established by the Supreme Court was that, yes, all the workers employed by the construction company squarely attract the definition of the term workman as found in Section 2L. And why? Because they are working for remuneration in a manufacturing process carried out by the project. The court basically recognized that the construction for this specific project constituted a manufacturing process, perfectly fulfilling our checklist. You definitely want to cite this case on your exam whenever you need to prove just how broadly the courts apply that manufacturing process clause.
All right, let's jump to Section 3, the definition of a factory.
Once again, we need to look at the foundational text of Section 2M before we can deconstruct it. A factory basically means any premises, including the precincts thereof, where a specific number of workers are working and in any part of which a manufacturing process is being carried on. But here's the kicker. The law draws a very distinct, hard line based on whether electricity, or power, is being used in that manufacturing process. You absolutely must contrast and compare these specific thresholds, because confusing the with power and without power headcount is exactly where students commonly lose points. So let's break it down. If the manufacturing process is carried on with the aid of power, the threshold is 10 or more workers. But if it is without the aid of power, that threshold doubles to 20 or more workers. And please note this absolutely crucial time frame. They don't all have to be working on the exact same day. If that number of workers was working on literally any day of the preceding 12 months, boom, the premises is legally a factory. Now, you know law exams absolutely love testing exceptions, right? So if you see these pop up in multiple choice questions, you need to remember what is strictly excluded from this definition. When you are computing that 10 or 20 worker threshold we just talked about, you have to include all the workers in different groups and relays in a day. That's your inclusion. But look closely at the exclusions. Even if a massive hotel or restaurant has 50 people cooking with the aid of power, it is strictly excluded. Mines governed by the Mines Act of 1952? Excluded. Mobile units of the armed forces and railway running sheds? Excluded. Seriously, burn these exceptions into your memory for test day. That brings us to Section 4, Case Study, Seelan Raj.
Okay, thinking back to that hook I threw at you at the very beginning of the explainer, let's finally find out the legal answer. You have a premises. You install an electronic data processing unit or a computer unit. Nothing else. Is it a factory?
And here is the answer, which brilliantly illustrates the ruling in Seelan Raj v. Presiding Officer. The court explicitly held that the mere fact that an electronic data processing unit or a computer unit is installed in any premises does not make it a factory, as long as no actual manufacturing process is being carried on there. The technology alone just doesn't trigger Section 2M. Having a physical manufacturing process is the absolute non-negotiable requirement. Oh, and a super quick side note for your exams. Remember that once a premises actually meets the definition of a factory, it immediately falls under strict government control. The law specifies that absolutely no factory can run without approval or a license. And who holds this ultimate power? It's the state government. The state government makes the rules relating to approval, licensing, and registration, and they are also the ones who hold the power to delicense and deregister factories.
All right, let's pull all of this dense legal material together in Section 5, Final Exam Takeaways.
If you are literally cramming the night before the test, these are the absolute must-remember facts you need to take away from this explainer. Number 1, Section 2L defines a worker broadly. It includes agency hires and even unpaid individuals, as long as they touch that manufacturing process. Number 2,
Use the Law Muhammad case to prove that construction workers on a project's manufacturing process are legally workmen. Number 3, for Section 2M, memorize those factory thresholds. 10 workers if you have power, 20 if you don't, within the preceding 12 months. Number 4, cite the Sealand Raj case to show that a room full of computers is not a factory unless a manufacturing process is actually happening. And number 5, never, ever forget your strict exclusions: armed forces, mines, railway running sheds, and hotels or restaurants.
So I'm going to leave you with this final mock exam prompt to really test your retention of those tricky exceptions. Ready? If a hotel employs 25 people using power for its commercial kitchen, is it a factory under Section 2M? Based on the exclusions we just reviewed, think carefully about exactly where the law draws the line. As you continue preparing for your exam, ask yourself, why did the legislature carve out these specific businesses? Keep reviewing these boundaries, trust in the structure we built today, and good luck with your studying.
All right, let's jump right into a highly testable topic for your upcoming exams. We are looking at the Factories Act of 1948, and specifically, we're zeroing in on the exact legal definition of an occupier. Mastering Section 2N of this act is pretty much your golden ticket to securing top marks. So grab your notebooks, get focused, and let's get you ready to absolutely ace this. So picture this. A tragic factory accident happens. Who actually takes the fall? I mean, who goes to jail or pays the massive fine? You know, it's not necessarily the floor manager, and it's definitely not just some HR head. The law looks for a very specific person to hold legally accountable, and that person is the occupier. Understanding exactly who this isn't just some dry academic theory. It's literally the real-world foundation of industrial safety law. Okay, let's dive into this. Here is your exact exam blueprint. We'll start with the ultimate control test. Break down how to identify the occupier across different entities, look at a fascinating case study on the corporate mask, cover the strict notice rules, and then wrap up with the general duties of occupiers.
Starting off with Section 1, the ultimate control test.
Now, when you're writing your exam answers, examiners are absolute sticklers for precise legal terminology. You need the exact phrasing from the statute. Under Section 2N of the Factories Act 1948, the occupier is defined as the person who has ultimate control over the affairs of the factory. I really want you to hear the emphasis on those two words, ultimate control. This isn't just about who manages the day-to-day shifts or who signs the local vendor checks. It's about who actually pulls the final strings. So, the crucial point is, ultimate control is the absolute key phrase you must memorize today. If you're asked to define an occupier and those two words are missing from your very first sentence, you are already losing points. It completely anchors the rest of the legal logic we're about to explore. Moving right along to Section 2, identifying the entity occupier. The law actually applies this ultimate control test quite differently depending on the structure of the business. For a firm or an association of individuals, any individual partner or member is deemed the occupier. For a company, it is strictly any one of the directors. And for a factory owned or controlled by the central or state government or a local authority, well, it's the specific person appointed to manage the affairs of that factory. It's a very strictly codified list that you just need to know inside and out. And to prove just how rigid this list is, let's look at a 2002 case. Container Corporation of India Limited versus Lieutenant Governor of Delhi. The court explicitly held that a company can't simply nominate any other employee to be the occupier. It has to be a director. A company can't just pass the buck to a plant manager or some administrative executive to shield their board of directors from liability. It's an absolute rule, no exceptions. Now, there is also a highly testable caveat regarding ship repair in dry docks that are available for hire. The Act essentially splits the liability here. The owner of the dock is deemed the occupier for basic infrastructure matters. Think things like providing suitable lighting and latrines under Sections 6, 7, and 11. But the owner of the ship, or their agent or master, is the occupier when it comes to the direct workers they employ and the machinery they use for the repair work. It's a dual liability concept. Well, actually, scratch that. It's more of a split liability situation, and examiners absolutely love to test it to see if you've really paid attention to the fine print. Let's move to Section 3 and see how this builds. Case study, corporate mask. So, let's see how this all translates into real-world jurisprudence. The case is Indian Oil Corporation versus Labor Commissioner. This is an incredibly important Supreme Court ruling from 1998, and it's a landmark decision that perfectly tests the boundaries of that ultimate control concept when the government is involved. Here is the mystery I want you to solve using what we just learned. In the case of the Indian Oil Corporation, who
actually has ultimate control? Is it the corporation itself acting as an independent entity, or is it the central government that originally established it? Think about how the ultimate control test applies here. Ultimately, who is pulling the final strings of those petroleum industry operations? And this brilliantly illustrates what the Supreme Court decided. They held that the central government retained ultimate control over the affairs of the corporation, including opening and running its factories. They introduced this really vivid concept of the corporate mask. The court essentially pierced the corporate veil, stating that acting through the corporation was merely a method employed by the central government to run its petroleum industry. So behind that corporate mask, the central government was the true occupier under Section 2N. It's a phenomenal application of the law and definitely one you want to cite in your essays.
All right, shifting gears to Section 4, the Occupier Notice Rules. Now we're moving from substantive definitions to procedural timelines under Section 7. Procedural timelines are honestly easy marks if you memorize them properly, but they're exactly where students tend to make careless errors. So listen closely. First, the occupier must send a written notice to the chief inspector at least 15 days before they begin to occupy or use any premises as a factory. That notice has to include vital details: name, nature of manufacturing, worker details, the whole shebang. Second, whenever a new manager is appointed, a written notice must be sent to the inspector with a copy to the chief inspector within 7 days after the date that person takes charge. Notice the distinct triggers here: 15 days before for occupying and 7 days after a manager takes charge. Make sure you get those directional timelines right. Finally, Section 5, General Duties of Occupiers. So, we know who the occupier is and we know how they declare themselves, but what does Section 7A actually require them to do day in and day out? Now, what's really interesting about this is how incredibly broadly these duties are defined by the statute. Every occupier must ensure, so far as is reasonably practicable, the health, safety, and welfare of all workers while they are at work in the factory. It's a massive umbrella responsibility, whether it's making sure the factory floor is clean, ensuring proper disposal of wastes, or preventing overcrowding. The buck ultimately stops with the occupier. They simply cannot delegate away this fundamental legal responsibility. Let's wrap this up with a quick exam-style hypothetical to test your new mastery of this topic. If a massive multinational firm opens a factory in India, can they just legally designate their local HR head as the occupier to shield their global board of directors from liability? Well, based on the Container Corporation case we talked about and the strict text of Section 2N, you should know exactly why the answer to that is a resounding no. Keep that ultimate control test at the front of your mind, review these concepts, and you are going to completely crush this exam question. Welcome, focused learners. Ready to conquer the Factories Act of 1948? This explainer is your ultimate study blueprint. Look, if you're prepping for your written exams, you already know this act is an absolute beast. It covers literally everything, from the air the workers breathe right down to the heavy machinery they operate. But to actually master it, and to get those top marks, we need to understand the folks who enforce it on the ground. I'm super excited to walk you through this today because, honestly, once you understand these key players, the whole act just kind of clicks into place. Let's get into it. Here's what we're looking at today. First, the legal precedent. Second, inspector's appointment and role. Third, key powers of inspectors. Fourth, certifying surgeons' medical oversight. And fifth, an overview of welfare measures. All right, part 1, the legal precedent. So let's anchor our whole understanding with a really solid, highly citable legal precedent. This is exactly what you need to hook your exam grader. Before you start memorizing section numbers and clauses, you've got to grasp the spirit of the law, right? If an essay question pops up asking about the fundamental purpose of the act, how do you open? You definitely don't want to just write, well, it protects workers. No way. You want to frame it as a crucial piece of social legislation. You need to show that examiner that you truly understand the power dynamics out there on the factory floor. And that brings us to this brilliant case study. The Ravi Shankar Sharma versus State of Rajasthan case from 1993 is literally your golden ticket for this. The court explicitly noted that the act is meant to provide protection to workers from being exploited by, and I quote, greedy business establishments. And it mandates the improvement of working conditions. This perfectly proves the act is social legislation designed for health, safety, and welfare. Keep this specific case study in the back of your mind as we go through the massive powers given to the enforcers. Those powers exist for one reason: to fulfill the mandate of this exact court ruling. Moving right along to part 2, inspectors, appointment, and role. Let's look at our first group of administrative enforcers, the inspectors. This is the absolute core of our explainer today. The inspector is the primary boots-on-the-ground authority, making sure the Factories Act is actually being followed.
Section 8 gives the state government the direct power to appoint qualified individuals and assign them strict local limits. Now notice two key things here for your notes. First, it's the state government making these appointments. Second, the people appointed must possess prescribed qualifications. You can't just pull someone off the street for this. They need the technical chops to walk into a really complex manufacturing facility and instantly spot a safety violation. And because the government assigns specific local limits, every single factory falls under a clearly defined jurisdiction.
Which brings us to Part 3, Key Powers of Inspectors.
Okay, Section 9 is a heavy hitter in the Act. Let's group these powers logically so you can effortlessly recall them under pressure during your written exam. First, think of the physical access and inspect flow. Imagine the inspector actually showing up at the site. Number 1, they have the power to enter any place used, or even a place they just have reason to believe is used as a factory. They absolutely do not need an invitation. 2, once they're in, they make a physical examination of the premises, the plant, the machinery, or any article or substance. 3, and examiners love to test this, they can inquire into any accident or dangerous occurrence. And listen to this detail. They can investigate whether the accident resulted in bodily injury, disability, or not. A near miss is totally enough. Plus, they can take on-the-spot statements from anyone they think is necessary for that inquiry.
Now, once the physical inspection is happening, the paperwork begins. Let's look at their administrative and seizure powers. An inspector can demand the production of literally any document relating to the factory. If they suspect something shady is going on, they have the power to seize or take copies of any register, record, or document. They don't just ask nicely to look at it, they can legally take it. On top of that, if they spot a dangerous chemical or a faulty machine part, they can take possession of that article or substance and hold on to it for as long as they need to examine it. They can also exercise any other prescribed powers. Think back to that Ravi Shankar Sharma case. These super aggressive inspection and seizure powers are exactly how they stop worker exploitation in its tracks.
To guarantee a flawless exam answer, use this exact contrast to completely separate the administrative authority of the inspector from the medical authority of the surgeon. The inspector? They're the detective, the compliance officer. They're checking the gears, scanning the registers, and testing the safety guards. But what about the actual physiological impact of the work on a human body? Well, that's where the inspector steps back and the certifying surgeon steps in. So Part 4, Certifying Surgeons, Medical Oversight. The really crucial point here is how the medical side of things is actually enforced. You simply can't run a safe factory without medical oversight, especially when you're dealing with hazardous processes or younger workers. Under Section 10, the state government appoints qualified medical practitioners to act as certifying surgeons within assigned local limits or for specific classes of factories. Just like the inspectors back in Section 8, these surgeons are state appointees, but their mandate is 100% health-focused. They might be assigned to a specific geographic area or maybe to a specific factory type. For instance, a surgeon who specializes in respiratory issues could be assigned specifically to all the chemical plants in a given state.
You can group their statutory duties into 3 main pillars for your exam. 1, certifying young workers. 2, monitoring dangerous jobs. And 3, conducting broad medical supervision. If a young person wants to work in a factory, they actually need a certificate of fitness from the surgeon, proving they have the physical capacity for a full day of work. The surgeon is also out there actively monitoring anyone engaged in prescribed dangerous occupations, keeping a close eye out for early signs of occupational diseases.
And here is where it gets really proactive. These surgeons aren't just sitting in an office waiting to do routine checkups, they are actively hunting for hazards. The surgeon steps in during sudden illness outbreaks that seem linked to the manufacturing process or working conditions. They also step in when a factory makes a change, like adopting a new manufacturing process or a new substance that creates a likelihood of injury to the worker's health. And of course, they step in proactively when young persons are about to be employed in any work likely to cause them injury. They are, quite literally, the medical guardians of the factory floor.
Finally, Part 5, Overview of Welfare Measures. So now that you know exactly who is enforcing the rules, the inspectors and the surgeons, what exactly are the rules they're enforcing? Well, the Act takes care of workers across several aspects: health in the working environment, safety including hazardous processes, general welfare, working hours for adults, employment rules for young persons, and annual leave with wages. This is your high-level checklist. Jot these 6 categories down right now because we are going to cover every single one of these topics in granular detail in our next explainer. But for now, just look at this brief overview through the lens of what we just learned. When we talk about health, like ventilation and dust control, who is checking that? The inspector. But if that dust causes an illness outbreak, the surgeon steps in. Safety and machinery fencing?
The inspector checks that under Section 9. Young persons needing fitness certificates? The surgeon grants those under Section 10. The entire act is this massive, interconnected web of worker protections held together by these two vital roles.
So let's wrap this up with a thought exercise. If a written exam question asks you to defend the powers of an inspector or a surgeon using the Ravi Shankar Sharma precedent we discussed, how would you structure that legal argument? Think about it. Why is it perfectly legal for an inspector to just walk into a private business unannounced, demand their private registers, and seize their machinery? Because, as the court ruled, without those aggressive powers, the state literally cannot protect workers from exploitation. The power to inspect is ultimately the power to protect. I really want you to chew on that connection. Review your notes on sections 8, 9, and 10, and get ready for our next explainer where we'll break down every single health, safety, and welfare mandate these incredible officers enforce. Keep studying, stay focused, and I'll catch you in the next one.